Lease note: Federal Reserve notes are not redeemable, and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves. This is taken from the official website of the United States financial expert, the United States Department of the Treasury, whose job it is to print the money to be utilized by the public, and note how they say that since the government declared bankruptcy in 1933 their notes have had no value. An official website of the United States government, U.S. Department of the Treasury. https://www.treasury.gov/resource-center/faqs/currency/pages/legal-tender.aspx. The Federal Reserve issues bookkeeping entry credit. There is no constitutional amendment permitting the Federal Reserve and/or the Treasury to create worthless items and declare them to be currency. The Constitution has held that the monies created by Congress must have a value, and this is not a market value but a national currency value. Federal Reserve bookkeeping entry credit is not regulated by Congress, making this process by the Federal Reserve, the issuance of bookkeeping entry credit, unconstitutional. That is, unless and until you can provide facts and conclusions of law, and not opinion, to the contrary. 91. The respondents admitted and stipulated that where an American alleged defendant and the undersigned before an American court, charged with the violation of a statute, law, code of the French Parliament, to which he mounts a defense upon an unconstitutional issue of a law violating his alleged Fourth and Fifth Amendment rights, and its being repugnant to the Constitution, the presiding judge would have committed an error in judgment were he to hold that said statute, law, code, regardless of how apparently corrupt and fascist this holding may seem to paint said court and judge, is not unconstitutional. And such a holding and statement of the judge is not a tacit affirmation on the part of said judge that the matter was improperly presented as an unconstitutional issue when it should have been presented as a non-constitutional issue, i.e. a law, statute, code outside and foreign to the Constitution, which would have acted to focus upon and address the nature of said statute, law, code and the want of relationship, contract or otherwise existing between said alleged defendant and the undersigned and the source of authority for the existence of said statute, law, code to which, for said want of relationship, said alleged defendant and the undersigned has no duty nor obligation to follow, comply with, nor obey. 92. The respondents admitted and stipulated that whereas the issue of a trial or hearing exists when the plaintiff and alleged defendant arrive at some specific matter in which one affirms and the others denies, a court does create the issue by asking the named defendant how he disputes to the charges. 93. The respondents admitted and stipulated that if there is a statute, law, code within, and upon, the face of an alleged charging document, instrument which alleges, charges a violation of an unconstitutional statute, law, code, or is from another state, or legal entity, or even a non-constitutional legislative entity, such as those statutes, laws, code cited from the United States Code, and state of, and local equivalent, including but not limited to the ACT of March 9, 1933 and any and all laws implemented based upon that alleged authority and foundation thereof, within and upon the face of the alleged warrant of arrest, alleged charging document, instrument, indictment, and alleged affidavits in support thereof within the above referenced alleged matter, an alleged defendant, and specifically the named alleged defendant and the undersigned within the above referenced alleged matter, in the act of entering a plea or verdict thereto, and therein, does thereby, and therein, admit to the geniuses of said alleged charging document, instrument, indictment, and does admit to the validity of the statutes, laws, codes cited therein, and does thereby form the issue for trial which would not exist without a plea, and without which there would not be anything before the court or jury for trial. 94. The respondents admitted and stipulated that it appears within, and upon, the face of the record of the alleged court of record in the above referenced alleged matter, the nature of the statutes, laws, codes cited within, and upon, the face of the alleged warrant of arrest, alleged charging document, instrument, indictment, and alleged affidavits in support thereof, as relied upon by said court to assume its jurisdiction in the case, cause and over and upon the parties therein, and the consequences of entering a plea, as established supra at proof of claim number 92 and 93, were not disclosed to the named alleged defendant within the above referenced alleged matter by any officer of said court and, or the United States of America, and state of, and local equivalents, and was rather actively concealed and hidden from the named alleged defendant and the undersigned by said officers, and such concealment does operate to constitute, establish acts of fraud upon and against the named alleged defendant and the undersigned within the above referenced alleged matter. 95. The respondents admitted and stipulated that the proceedings in which the named alleged defendant and the undersigned were subjected to within the above referenced alleged matter were in equity, chancery and/or admiralty, and the conflict was with an non-constitutional source of authority for the existence of the statutes, laws, codes alleged, charged as violated within, and upon, the face of the alleged warrant of arrest, alleged charging document, instrument, indictment, and alleged affidavits in support thereof. 96. The respondents admitted and stipulated that courts and the legal system today, and specifically the alleged court of record within the above referenced alleged matter, cannot, and do not, recognize and proceed upon common law crimes, offense, and therefore acts, which are made crimes, offenses, are made so by statute, or rather code. 97. The respondents admitted and stipulated that all crimes are commercial. See, Constitution for the United States of America C. 1819, Art. I, Section 8, cl. 3 and 18, accord specifically the ACT of March 9, 1933 and any and all laws implemented based upon that alleged authority and foundation, Title 27 CFR Section 72.11. 98. The respondents admitted and stipulated that the want of subject matter jurisdiction, and all other facets as well, can stop a court, and specifically the alleged court of record within the above referenced alleged matter, from proceeding, and does void all orders, decisions, judgments, and the like of said court as it cannot be waived, may be asserted at any time, even after trial for the first time, and is not affected by nor negated by the act of entering a plea, not even a guilty plea, as such would confess nothing, and this want of subject matter jurisdiction, and all other facets as well, whether ensuing from a fatally defective alleged warrant of arrest or alleged charging document, instrument, e.g. an indictment as in the above referenced alleged matter, for employing, using and citing unconstitutional statutes, laws, codes, or non-constitutional statutes, laws, codes without nexus relationship, e.g. contract or otherwise, established and existing between the parties, does effectuate the same result, i.e. the judgment is void and a complete nullity ab initio, unenforceable, and without binding force, effect and effect, even before reversal. 99. The respondents admitted and stipulated that whereas other state supreme courts have held these so-called revised codes, or however termed, styled, not to be the law of their respective states, the United States Code, stative, and local equivalents, is not any different from these other so-called revised codes and is not the law of the United States of America, stative, and local equivalents, instrumentalities. 100. The respondents admitted and stipulated that all jurisdiction with, and of, the United States of America, and stative, and local equivalents, are by contract, and said contractual constraints are binding upon any and all courts within said juridical constructs, and the jurisdiction exercised therein. 101. The respondents admitted and stipulated that the executive power, i.e. the administrative branch of government, state and federal, national, as created, ordained, and established within the written document, instrument for its existence, is limited and guided by the law of the land. 102. The respondents admitted and stipulated that the law of the land and due process of law do have the same meaning, and the law intended by the Constitution, state and federal, national, is the common law. 103. The respondents admitted and stipulated that the due process of law clause is expressly written within the Constitution for the United States of America C. 1819, does make and establish the common law, the law of the land. 104. The respondents admitted and stipulated that the common law is the foundation of due process of law. 105. The respondents admitted and stipulated that due process of law and the law of the land does declare that a man cannot be deprived of his liberty, or property, unless by the judgment of his peers or the law of the land. 106. The respondents admitted and stipulated that due process of law and what constitutes the same is not determined by the legislative power of government, state and/or federal, national, and specifically that is exercised by the General Assembly of the present existing the United States of America, and stative, and local equivalents, instrumentalities, within and/or through its statutes, codes, laws, and as a restraint upon the legislative, as well as the executive and judicial powers of government. 107. The respondents admitted and stipulated that whereas the Congress of the federal government is not free to make any process it deems fit as constituting due process of law, the General Assembly of the United States of America, and stative, and local equivalents, instrumentalities, are not free to make any process they may deem fit as constituting due process of law. 108. The respondents admitted and stipulated that what constitutes due process of law is to be ascertained by an examination of the settled usages and mode of proceeding in the common and statute laws of England before the immigration of the people to this land and adoption of any constitution. 109. The respondents admitted and stipulated that the due process of law clause, i.e. the common law as defined herein above, does govern what the law on arrest is on the land, and where it exists, the most that statutes can be, and specifically as contained within the United States Code, and state of, and local equivalents, is declaratory of the common law, and, if there is no direct language in the Constitution of a state, and specifically as this relates to and bears upon said Constitution for the United States of America c. 1819, directing what procedure or process is to be followed, the common law made the law of the land through the Due Process Clause of the Constitution for the United States of America c. 1819 is to be the due process of law followed and enforced within the states, as opposed to some legislative statutes, codes validly enacted or otherwise, or a city ordinance. 110. The respondents admitted and stipulated that a law enforcement officer, however such may be termed, styled, who does not abide by the law of the land, i.e. the common law as adopted through the Due Process Clause of the Constitution for the United States of America c. 1819, are trespassers. 111. The respondents admitted and stipulated that in matters relating to, and bearing upon, arrests, fundamental law, i.e. the organic law, i.e. the Constitution, is controlling over and upon legislative statutes, and specifically the United States Code, and state of, and local equivalents, and is therefore the prevailing law. 112. The respondents admitted and stipulated that due process of law by which a man may be deprived of his liberty, and property, is that process which existed at common law. 113. The respondents admitted and stipulated that a man cannot be arrested upon a warrant without due process of law. 114. The respondents admitted and stipulated that due process of law does have the same meaning throughout America. 115. The respondents admitted and stipulated that in a criminal proceeding where an arrest is made without warrant, an invalid warrant, or a warrant illegally, unlawfully executed, the burden is upon the United States of America, and/or state of, and local equivalents, as this matter relates to and bears upon the above-referenced alleged matter, to justify the arrest upon said warrant, or lack thereof, and subsequent criminal proceedings, as one not violating of constitutional provisions, and the invalidity of the arrest will render any search invalid and all evidence obtained inadmissible. 116. The respondents admitted and stipulated that the warrant used, employed by an arresting officer in executing said arrest must be in said officer's possession. 117. The respondents admitted and stipulated that possession of a warrant of arrest by the arresting officer executing said warrant does mandate it must be in the hand or pocket of said officer, and said possession does mandate, require, and establish that said warrant must be so nearby as to show it upon request with reasonable promptness. 118. The respondents admitted and stipulated that where an offense is not committed in the presence of an officer, as in the above-referenced alleged matter, in making an arrest for said offense, said officer does need to have the warrant for arrest in his actual possession if the arrest is to be lawful. 119. The respondents admitted and stipulated that knowledge of the issuance and existence of a warrant of arrest by the party named therein does not relax, or even do away with, the requirement that the arresting officer must be in possession of the warrant. 120. The respondents admitted and stipulated that a warrant of arrest must be shown and read to a man allegedly named therein, and being placed under arrest, or informed of being under arrest, if requested to do so. 121. The respondents admitted and stipulated that failure to show or display a warrant when a warrant for an arrest allegedly exists, the arrest does thereby, and therein, become unlawful, illegal. 122. The respondents admitted and stipulated that the primary reason for the officer to have the warrant in his possession when making an arrest under the warrant is so that it can be shown to the one arrested, so that he may know the authority by which he is being deprived of his liberty. 123. The respondents admitted and stipulated that the argument that officers are free to arrest because there is a warrant outstanding is nullified by the requirement of law that one arresting under a warrant must show it if requested to do so, which is manifestly impossible unless the arresting officer has the warrant in his possession at the time of arrest. 124. The respondents admitted and stipulated that any statute, code, law, validly enacted or otherwise, requiring the warrant to be shown upon arrest, and specifically within, the United States Code, Federal Rules of Civil Procedure, Supplementary Rules of Admiralty, and the Federal Rules of Criminal Procedure, and state of, and local equivalents, is but declaratory of the due process of law. Procedures that must be followed in an arrest, and therefore a statute requiring a warrant to be shown upon arrest is not needed, and where such a statute exists, it is merely redundant in nature. 125. The respondents admitted and stipulated that the reason for the duty of the arresting officer executing a warrant of arrest to explain the cause, for which the warrant issued, to the party arrested is to state the nature and substance of the process which gives the arresting officer the authority which he professes to exercise, and if it is demanded of the arresting officer, to produce and exhibit it to the arrested party for his perusal that he may have no excuse for resistance. 126. The respondents admitted and stipulated that a prima facie invalid warrant will not be, and is not, regarded as any warrant, and an officer attempting to execute an arrest thereunder of the party named therein is not protected by it. 127. The respondents admitted and stipulated that both a proper subject matter, in personam, political, geographical and other jurisdiction are necessary and essential for a valid warrant. 128. The respondents admitted and stipulated that the question of jurisdiction can be raised at any time, and consent and/or waiver cannot confer or grant jurisdiction, and a court, and specifically the alleged court of record within the above referenced alleged matter, does not have any authority to proceed where it appears from the record that it has no authority due to an insufficient warrant of arrest. 129. The respondents admitted and stipulated that whenever a warrant of arrest is invalid on its face, or where it is only a summons, the arresting officer, or officer attempting to execute service thereof, upon the party named therein, said officer is liable for damages. 130. The respondents admitted and stipulated that the requirements of what a warrant of arrest should contain does depend primarily on constitutional mandates and common law principles. 131. The respondents admitted and stipulated that the common law does require that a warrant of arrest be issued for an arrest only after a formal charge is made under oath, and an arrest is not valid if not based upon a sworn affidavit. 132. The respondents admitted and stipulated that a warrant of arrest does require the individual review of a neutral judicial officer, i.e. magistrate, justice of the peace, or judge who is learned in the law and qualified to determine if probable cause exists to issue said warrant, and does require the signature of said judicial officer, which cannot be rubber-stamped with the judicial officer's name by some clerk or administrative employee, and such a practice of rubber-stamping the judicial officer's name does not constitute signature of said officer, and is thereby, and therein, void and invalid. 133. The respondents admitted and stipulated that a warrant is regarded as insufficient and thus void if, on its face, it fails to state facts sufficient to constitute a crime. 134. The respondents admitted and stipulated that a designation or description of the offense should be written in the warrant. 135. The respondents admitted and stipulated that whereas inaccuracies and imperfections do vitiate a warrant which substantially charges an offense, a complaint recited in substance in a warrant and which is verified merely on information and belief and does not thereby, and therein, state facts sufficient to constitute an offense, said warrant must be held to be invalid on its face. 136. The respondents admitted and stipulated that an affidavit that merely states belief in the guilt of the accused is insufficient to support a warrant of arrest. 137. The respondents admitted and stipulated that an affidavit which is based upon a presumption or belief of crime does not give jurisdiction to the court, and specifically as this matter relates to and bears upon such affidavit and the alleged court of record within the above referenced alleged matter, to issue a warrant, and a law enforcement officer, however termed, styled, cannot execute a warrant, which is essentially local, outside their jurisdiction. 138. The respondents admitted and stipulated that the officers executing a warrant of arrest is bound to know if under the law, the warrant is defective, and not fair on its face, and he is liable as a trespasser if it does not appear on its face to be a lawful warrant, and said officers' ignorance is not an excuse. 139. The respondents admitted and stipulated that the following are the basic requisites and essentials needed to make a warrant of arrest valid. 1. A warrant is to be issued by a judicial officer and signed by him. 2. It must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. 3. It cannot be based upon mere belief or suspicion, but upon probable cause. 4. The warrant is to list a complaint which is to state the offenses committed and the facts that constitute a crime. 5. A warrant is to contain an affidavit of the person making the charge under oath. And 6. It must truly name the man to be arrested, or describe him sufficiently to identify him. 140. The respondents admitted and stipulated that in commercial law, any document or instrument, e.g. inter alia, legal briefs, securities, promissory notes, contracts, and affidavits must contain seven essential elements to be valid, and any of these seven essential elements which are missing, does render the document or instrument commercially defective, void, or expressly fraudulent. 141. The respondents admitted and stipulated that these seven essential elements as applied to an affidavit in support of a warrant of arrest or a charging document, instrument, are, 1. Accurate identification of the parties to the document, or instrument, or dispute, 2. Nature and content of the allegations or claims set forth with particularity, 3. Ledgering, accounting of the remedy or relief sought as recompense or compensation for specific wrongs, or contractual violations, or defaults, 4. Evidence of solvency, identification of the property sought, pledged as the stakes over which the dispute occurs, to be forfeited to the prevailing party to pay the debt, damage and satisfy the judgment. 5. Facts and law, specific laws violated and facts in evidence by exhibit. 6. Certification, statement under oath by party asserting an allegation or claim that everything asserted is true, correct, and complete, whether criminal or civil. And 7. Witnesses, third-party certification substantiating the actual lawful, legal identity of the party executing the document or instrument. 142. The respondents admitted and stipulated that the Fourth Amendment to the Constitution for the United States of America C-1819 does apply to arrests made and executed under warrants of arrest, and does govern and regulate how such warrants are to issue, and does make the issuance of such warrants to be solely upon probable cause supported by oath or affirmation absolutely mandatory and essential for said warrant of arrest to be valid, lawful, and in compliance with due process of law or the law of the land, i.e. common law rules and principles established and present in this land before the adoption of said constitution, as practiced and administered in England prior to the immigration of the people to this land. 143. The respondents admitted and stipulated that where an arrest is made and executed without a warrant of arrest, which is recognized and authorized by the common law only for a select and specific class of offenses, and therefore outside the provisions of the Fourth Amendment to the Constitution for the United States of America C-1819, the standards of due process of law or the law of the land, i.e. common law rules and principles, must be applied to said arrest, and failure to apply said rules and principles to said arrest would, and does, constitute and establish said arrest as a false arrest, and therefore void. 144. The respondents admitted and stipulated that whereas the undersigned has never seen the original, nor been presented with a copy, certified or otherwise, of the alleged warrant of arrest, and the alleged affidavit in support thereof, employed, used within the above-referenced alleged matter by the arresting officers, and therefore has no reason to believe a valid, lawful, and properly supported warrant of arrest which truly names, identifies, references the undersigned exists, that such a warrant of arrest for the undersigned does not exist, and is not signed, authenticated by a lawful judicial officer, and does not allege, charge of violations of validly enacted statutes, laws, and therefore does not establish, create a crime, offense within the jurisdiction of the judicial officer signatory thereon, and does not create all facets of jurisdiction for the alleged court of record within the above-referenced alleged matter, and the affidavit in support thereof does not comply with all seven points of a seven-point document, instrument, and any signature of a judicial officer appearing upon the face of the warrant of arrest as, was not, at the time of affixing his signature thereon, and thereto, validly and lawfully holding his office, having perfected title thereto, and thereby not lawfully in possession and use of the plenary powers resident therein, and not containing all additional requisites and essentials as set forth above within proof of claim number 139, and in all areas is not in accordance with and pursuant to rules and principles as established and ordained by the due process of law or the law of the land. 145. The respondents admitted and stipulated that without a valid and lawful warrant of arrest being in existence for the undersigned within the above-referenced alleged matter, a defense against the claim of false arrest and false imprisonment does not exist for the respondents. 146. The respondents admitted and stipulated that the law does set such a high value upon the liberty of a man that even an attempt to unlawfully arrest said man is esteemed a great provocation. 147. The respondents admitted and stipulated that an arrest may be made without any physical force or touching of the arrested man by the arresting officer. 148. The respondents admitted and stipulated that any unlawful or illegal restraint of a man's personal liberty by the act of another, and specifically as this relates to and bears upon the arresting officers within the above referenced alleged matter, does give the man so restrained a cause of action and claim for false arrest and false imprisonment resulting therefrom, against the one causing the unlawful or illegal restraint, and any restraint executed by fear or force is prima facie unlawful. 149. The respondents admitted and stipulated that in all cases of arrest in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered, i.e. there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit, under the belief and impression that submission was necessary. 150. The respondents admitted and stipulated that any restraint, however slight, upon a man's liberty to come and go as he pleases, does constitute an arrest. 151. The respondents admitted and stipulated that when a man has shown that he was arrested, imprisoned, or restrained of his liberty by another, the law does presume it to be unlawful till proven otherwise. 152. The respondents admitted and stipulated that in a claim of false arrest and false imprisonment, good faith on the part of the arresting, restraining officers, persons is not a justification for the custody, detention or imprisonment, and a lack, want of reasonable or probable cause, and malice are essential elements of the action, claim, and are therefore not viable and acceptable defenses against said action, claim. 153. The respondents admitted and stipulated that where an unlawful arrest and imprisonment are claimed to have been for the public good, such a defense will not stop damages. 154. The respondents admitted and stipulated that a belief in the guilt of a man, no matter how strong or well-founded in the mind of an arresting officer's persons, is a not justification against a claim of false arrest and false imprisonment. 155. The respondents admitted and stipulated that a man's liberty does not depend upon good faith merely, but upon legal rules governing official action. 156. The respondents admitted and stipulated that in claims, actions of false arrest and false imprisonment, the arresting officer's persons can avoid liability only by pleading justification for the arrest and all other arguments must necessarily fail. 157. The respondents admitted and stipulated that the guilt of a man arrested does not have any bearing upon the legality of the arrest. 158. The respondents admitted and stipulated that even where a man has pled guilty, the arresting officer's persons can still be liable for false arrest, and therefore, it has been held that consent to an unlawful arrest will not excuse an officer's persons from his acts, and the law permits such a claim to be made. 159. The respondents admitted and stipulated that a false, or unlawful, arrest is in and of itself an assault, or an assault and battery, trespass, or a graver offense, and the law does regard such arrests as any other assault which may be resisted by the assaulted, and the officer's persons making the arrest is regarded as a personal trespasser. 160. The respondents admitted and stipulated that a man can resist the unlawful seizure of personal property sought or forcefully taken without warrant, i.e. a warrant outside, and foreign to, the law of the land or due process of law without nexus relationship thereto, contractually or otherwise, or a warrant invalid on its face and not in compliance with requirements and prohibitions of the Fourth Amendment to the Constitution for the United States of America 1819, and such personal property does include, inter alia, fingerprints, photographic images of the man, bodily fluids, DNA, RNA, exemplars, and the like. 161. The respondents admitted and stipulated that the law that allows a man to resist an unlawful arrest is the same law that allows a man to repel an attack or assault upon his self, and said law is the law of self-defense and self-preservation, which is a man's unalienable right to in the protection of his life, liberty, and property from unlawful attack or harm, and such right is recognized and secured by the Constitution for the United States of America c. 1819. See Constitution for the United States of America c. 1819 Preamble, Articles in Amendment I, 2, IV, V, V, Ix, and X, in pari materia to all other state constitutions. 162. The respondents admitted and stipulated that the Supreme Court of the United States and every other court in the past deciding upon the matter, has recognized that at common law a man had the right to resist the illegal attempt to arrest him, and it has been held that a man can resist any arrest where he has reasonable grounds to believe that the officer's persons is not acting in good faith, and that by submitting to arrest and being disarmed he will, by reason of this fact, be in danger of great bodily harm or of losing his life. 163. The respondents admitted and stipulated that the common law or law of the land does draw certain limitations upon how and when an arrest can be made, and that all arrests which are to be lawful must necessarily be grounded in and upon such principles, and one such principle is that an arrest must be founded upon probable cause of guilt, and not mere suspicion, for the two must exist together. 164. The respondents admitted and stipulated that the word suspicion as used and employed within codes and statutes today, and specifically within the United States Code, state of, and local equivalents, instrumentalities, is so used and employed to authorize arrests which the common law or the law of the land prohibits, and upon defeat of said cause, to justify arrest for yet some other non-related cause from the first, in short, justification to conduct a mere hunting expedition with the hope of bagging some prize. 165. The respondents admitted and stipulated that the wisdom of the ages, which brought the law on arrests, was, and is, boldly declared in the Magna Carta, which states, "No one shall be arrested or imprisoned but by the law of the land." 166. The respondents admitted and stipulated that the undersigned, as well as any man today, was not arrested upon, and under, a warrant of arrest in accordance with, and pursuant to, rules and principles established and ordained within, under, and by, the law of the land. 167. The respondents admitted and stipulated that the restrictive principles of common law, which though annoying to those in government in their attempts to get the crooks and bad guys, are purposely so in order to restrict those in government and make them follow set procedures, and thereby, make it difficult for those in government to deprive men of their rights, as the common law or law of the land prescribes that in order to safeguard the rights of the innocent, the guilty must on occasion go free. 168. The respondents admitted and stipulated that whereas the common law recognizes and authorizes arrests without warrants only in cases where the public security requires it, such interests are confined only to felonies and breaches of the peace committed in the presence of an officer. 169. The respondents admitted and stipulated that it is a fundamental rule of procedure well grounded in the common law, that where an arrest is made, the alleged offender is to be taken before a magistrate to be dealt with according to law. 170. The respondents admitted and stipulated that whereas an offender is to be taken before a magistrate to be dealt with according to law upon arrest, such fundamental rule of procedure is to be observed without delay, or without unnecessary delay, and the failure in the observance of said procedural rule does render the arresting officer's persons liable for false imprisonment. 171. The respondents admitted and stipulated that where an arrest is lawful, a failure on the part of the arresting officers, persons in observing their duty to take the arrested man before a magistrate, and to do so without delay or unnecessary delay, will be regarded as false imprisonment. 172. The respondents admitted and stipulated that this fundamental procedural rule of taking a man upon arrest before a magistrate without delay, or unnecessary delay, is the due process of law or the law of the land to be followed, and a false imprisonment does ensue from the arresting officers or persons dropping off said man to a jail for detention and custody therein, as said officers' persons are not so authorized to act in such manner under the law of the land. 173. The respondents admitted and stipulated that the only reason that can justify having an arrested man in jail or detained custody by the arresting officer's persons is a necessary step in bringing the man before a magistrate, and therefore the detainment of said man in a jail, police office, station, barracks, and the like for purposes of booking, fingerprinting, investigating, interrogation, and the like is unlawful and illegal. 174. The respondents admitted and stipulated that even in matters involving the most severe, serious of offenses, as in felonies, the arresting officer's persons is still duty-bound, required to bring a man placed under arrest before the nearest magistrate or court as a matter of fundamental law without delay or unnecessary delay, and said arresting officer's persons is liable for false imprisonment if he arrests with the intent of only detaining, or if his unreasonable delay causes a detainment, thereby failing and or grossly neglecting his duty and observance thereof. 175. The respondents admitted and stipulated that where a man is arrested and taken to jail, or police station, or the like, and detained there with no warrant issued before the arrest, it is false imprisonment. 176. The respondents admitted and stipulated that to take an arrested man to a jail, police station, or the like to be detained and fingerprinted, measured, photographed, booked, and the like before said man is ever brought before a magistrate is a violation of his rights, and is proof of the arresting officer's person's intent not to observe his duty in this matter and his disregard of, and for, his duty incumbent upon him to fulfill and observe. 177. The respondents admitted and stipulated that an arrested man's right to be promptly taken to a judicial officer for hearing, examination, and the duty of the arresting officer's persons to protect said right, does not depend upon statute law of the United States of America as may be contained within the United States Code, and state of, and local equivalents. 178. The respondents admitted and stipulated that this rule of law requiring an arresting officer's persons to bring the arrested man before a magistrate, or judicial officer having jurisdiction, is the same throughout all the states composing the American Compact, and cannot be abrogated by statute as may be contained within the United States Code, state of, and local equivalents, and said rule has been upheld within the federal courts, and is prescribed within said courts' rules. 179. The respondents admitted and stipulated that the arresting officer's persons is guilty of official oppression and neglect of duty when they willfully detain a man without arraigning him before a magistrate within a reasonable time. 180. The respondents admitted and stipulated that the rule of law requiring that an arrested man be brought without delay, or unnecessary delay, directly to a court or judicial officer having jurisdiction is due process of law or the law of the land, and as such, this procedural requirement cannot be abrogated by statute as may be contained with the United States Code, state of, and local equivalents. 181. The respondents admitted and stipulated that it is a fundamental rule of law that one who abuses an authority given him by law does become a trespasser ab initio, i.e. he becomes a wrongdoer from the beginning of his actions. 182. The respondents admitted and stipulated that where an arresting officer's persons fails to take a man he has arrested before a proper judicial officer, or where said officer's persons causes an unreasonable delay in doing so, or having failed to procure, obtain a proper, valid warrant for the detention of the arrested man, said officer's persons does become a trespasser ab initio, and is thereby guilty of false imprisonment, and such failure or delay in his official duty does render said arrest unlawful. 183. The respondents admitted and stipulated that the office of the President Judge is charged with the administration and oversight of all proceedings, matters, cases, and the like within purview of the whole of the court, past and present, and is therefore the office of the principal of, and over, all the offices of the Judge acting in their capacity as agents of the principal, and the same is true for the office of the United States Attorney and office of the Attorney General, and state of, and local equivalents. 184. The respondents admitted and stipulated that when an arresting officer's persons fails to perform part of his duty, and it impinges upon the rights of a man, he is deemed to be a trespasser ab initio because the whole of his justification fails, and he stands as if he never had any authority at all to act. 185. The respondents admitted and stipulated that the basis of this well-established procedural rule of law in taking an arrested man without delay, or without unnecessary delay, directly before a court or judicial officer having jurisdiction is to avoid having the liberty of the arrested man unjustly dealt with by extrajudicial acts of executive officers, i.e. law enforcement officers and public officers however termed, styled. 186. The respondents admitted and stipulated that arresting officers are executive officers. 187. The respondents admitted and stipulated that the detainment of a man upon arrest is a judicial question, and a judicial officer is the sole authority to decide if there are grounds for holding the man arrested, or whether he must be further examined by trial, or if he is to be bailed and released, and the taking of said man to a jail to be booked without first honoring this duty is unlawful, or to detain said man to enable the arresting officers to make a further investigation of the alleged, suspected offense against said man is also unlawful. 188. The respondents admitted and stipulated that executive officers or clerks are not to determine if a man under arrest is to be held or released upon bail, and are not to fix the amount of bail, and such power to so determine is judicial. 189. The respondents admitted and stipulated that executive officers, i.e. arresting officers, having arrested a man cannot hold said man in order to complete paperwork or make out reports. 190. The respondents admitted and stipulated that good faith does not justify an unreasonable detention and deprivation of one's liberty caused by a failure or delay in bringing one arrested before a magistrate. 191. The respondents admitted and stipulated that it is a common practice for an arresting officers to drop a man they have arrested off at a police station, county jail, or the like and leave said man in the custody of others, and such a practice does not thereby, and therein, relinquish the duty of the arresting officers to the arrested man, and said officers cannot therefore claim exception of liability when the others to whom they dropped said man off into the custody have failed to fulfill the arresting officers' duty and take said man without delay, or unnecessary delay, directly before a proper, valid judicial officer having jurisdiction, as the arresting officers are responsible for the arrested man, and cannot rely on others to perform their duty. 192. The respondents admitted and stipulated that whereas one of the most common defenses raised in actions, claims of false imprisonment involves arguments of whether the delay in bringing one to a court was reasonable or necessary, such does depend upon the circumstances of the particular case, and is a question for the jury. 193. The respondents admitted and stipulated that the common law procedural rule for due process of the law made the law of the land through express constitutional provisions is that an arresting officer's persons is to present the arrested man without delay to a magistrate, having jurisdiction, and said procedural rule of law does mean no delay of time is allowed which is not incident to the act of bringing said man before a magistrate, and said common law procedural rule of law does nullify and void all present-day statutory requirements of 24 hours, 36 hours, 72 hours, or however many hours, days said statute may stipulate as contained within the United States Code, state of, and local equivalents, which, by their very existence, does constitute blatant acts of tyranny and declarations thereof. 194. The respondents admitted and stipulated that a man who has been arrested and subjected to procedures known as booking procedures, which include, inter alia, photographing, measuring, fingerprinting, and the like, are not lawful, and are not necessary to detect and arrest a man, and are not necessary to prevent crime, and is criminal in character, and does constitute an assault, and everyone concerned, participating therein is liable civilly for damages arising from the injury to, and upon, said man subjected to said procedures, but also to criminal prosecution under the United States Code, state of, and local equivalents, as operating upon, and over, all voluntary commercial indentures to the United States of America, state of, and local equivalents, as agents of said government. 195. The respondents admitted and stipulated that any present-day statute which may be contained within the United States Code, state of, and local equivalents, which mandates the fingerprinting of any and every man arrested, a practice the common law or the law of the land permits only after, upon conviction, in order to allow a man to be admitted to bail, or for any other purpose, excuse, is a serious invasion upon the liberty of said man, and such a statute is unconstitutional or non-constitutional without nexus of relationship, i.e. contract. 196. The respondents admitted and stipulated that there is not any right, authority given to government, and specifically the government of the United States of America, state of, and local equivalents, instrumentalities, by the common law or the law of the land, to take fingerprints prior to conviction within a criminal proceeding. 197. The respondents admitted and stipulated that any court decisions which may appear to strike down the common law or the law of the land principles which act to prohibit fingerprinting, measuring, and photographing of an arrested man prior to conviction within a criminal proceeding is based upon principles of some other non-constitutional source of law affording the court the ability to apply the doctrine of constitutional avoidance to the issue through said courts taking silent judicial notice of some contract, real or presumed, expressed or implied, revealed or unrevealed, existing between the parties to the issue before the court, such as principles of equity and/or admiralty. 198. The respondents admitted and stipulated that the compulsory taking of samples of an arrested man's blood, urine, hair, fingerprints, exemplars, and the like is an unlawful taking of said man's property without due process of the law and compensation, for a violation of said man's personal privacy, an unlawful attack and breach of said man's right not to be compelled to give self-incriminating evidence, and an assault and battery upon said man. 199. The respondents admitted and stipulated that it can be concluded there are at least five reasons why the acts of compulsory fingerprinting, blood testing, measuring, photographing, DNA, RNA extraction, exemplars, and the like are unlawful, and said reasons are, 1. They are an invasion of a man's right of privacy. 2. Such compels evidence to be used as self-incriminating evidence. 3. Such as an assault and/or battery. 4. Such violates due process of the law or the law of the land in the taking of a man's property. And 5. Prohibits bail when refused, if refusal is possible, and thereby infringes on one's liberty. 200. The respondents admitted and stipulated that any court decisions which may appear to have struck down the common law or the law of the land principles which act to prohibit the compulsory taking of samples of an arrested man's blood, urine, hair, DNA, RNA, exemplars, and the like upon arrest, during any proceeding within the prosecution, or any process of evidence collection, and any statutes as may appear within the United States Code, state of, and local equivalents, authorizing such, is based upon principles of some other non-constitutional source of law affording the court the ability to apply the doctrine of constitutional avoidance to the issue through said courts taking silent judicial notice of some contract, real or presumed, expressed or implied, revealed or unrevealed, existing between the parties to the issue before the court, such as principles of equity and/or admiralty. 201. The respondents admitted and stipulated that a man D.B.A., as magistrate, justice of the peace, or judicial officer, in order to be validly in possession and use of the plenary powers resident within his office, must have perfected title to said office, and said perfection is accomplished through valid and lawful oath of office and bond thereon. 202. The respondents admitted and stipulated that the failure of a man D.B.A., as magistrate, justice of the peace, or judicial officer, in perfecting title to his office as set forth above, is operating under a serious, severe disability of capacity acting to bar his lawful access to said office, possession and use of the plenary powers resident within said office, and due to his disability, said office is vacant, and therefore does render all acts performed by said man under said disability void, and does render said man for all acts performed while under said disability, guilty of, inter alia, false personation, false pretenses, usurpation, fraud, official oppression, fraudulent and deceptive business practices, and trespass ab initio, and thereby, and therein, does render said man liable for damages arising from all injuries he caused, subjected to, and inflicted upon the arrested man brought before him. 203. The respondents admitted and stipulated that an arrested man brought before a man D.B.A., as magistrate, justice of the peace, or judicial officer, which operating, functioning under a disability of office through his failure to perfect title thereto and lawfully possess and use the plenary powers resident therein, does not fulfill the well-established and settled fundamental procedural rule of law established as due process of the law ordained through the law of the land by express constitutional provision therein, and a man under arrest brought before such a magistrate, justice of the peace, or judicial officer does constitute and establish an unreasonable, unnecessary, and willful delay, and does constitute and establish, inter alia, failure of process, official oppression, gross negligence, and false imprisonment. 204. The respondents admitted and stipulated that the undersigned within the above referenced alleged matter was not brought before a magistrate, justice of the peace, or judicial officer having perfected title to said office through a valid oath and bond thereon, and therefore was not exercising, employing the plenary powers resident within said office unlawfully, and was acting under color of law, false pretenses, false personation, fraudulent and deceptive business practices, fraud, official oppression, and said office was vacant, and said warrant of arrest and writ of detainment was not obtained, procured from a magistrate, justice of the peace, or judicial officer having lawfully perfected title to his office. 205. The respondents admitted and stipulated that all acts of the magistrate, justice of the peace, and/or judicial officers within the above referenced alleged matter as they relate to and bear upon the undersigned therein, for reasons that have been set forth already, are void ab initio thereby, and therein, establishing and constituting the entire alleged matter as referenced above void ab initio along with the unlawful or false imprisonment of the undersigned therein to date. 206. The respondents admitted and stipulated that whereas in many of the older court cases we find the declaration, the law is very jealous of the liberty of the citizen, said law is the common law, and it does declare that, one who interferes with another's liberty does so at his peril. 207. The respondents admitted and stipulated that false imprisonment does consist of any type of unlawful restraint or interference with the personal liberty of a man, and is a trespass. 208. The respondents admitted and stipulated that false imprisonment is classified as a tort under the common law, and also as a crime. 209. The respondents admitted and stipulated that false imprisonment has been labeled as a tort, a trespass, an assault, a wrong, damage, and an injury, giving the man so affected cause to bring process for relief and remedy against the offending man, party. 210. The respondents admitted and stipulated that injuries to the liberty of a man are principally termed false imprisonments or malicious prosecutions.